to offer some witnesses in support. First, Mr. John Geesman on behalf of the Alliance for Nuclear Responsibility. Thank you.
Thank you, Senator Monning. I want to be very clear from the outset. I'm an attorney for the Alliance for Nuclear Responsibility. My client is firmly of the belief that it would be in the best interest of PG&E's ratepayers if the plant closed tomorrow. But it's been very clear for a number of years. The Energy Commission, of which I'm a former member, has published reports for over a decade now about the concentration of the county tax base in PG&E, the potential adverse impact on schools in particular is a severe risk that truly needs to be mitigated by the ratepayers of PG&E across Northern California that have benefited from the electricity output of the plant. Much of the assessment of the risk of closure has been focused on the prospect that the United States Nuclear Regulatory Commission will not extend licenses that expire in 2024 and 2025. I want to emphasize my professional judgment that a much larger risk exists among decisions likely to be made by state agencies. The decision to close this plant will be influenced much more by Californians than by a faceless bureaucracy in Washington. The State Water Resources Control Board, as you know, is considering whether to apply its policy against once-through cooling to Diablo Canyon. Every other power plant along the coast has been forced into compliance. Diablo Canyon represents 78% of the existing once-through cooling water flows. The Water Board's policy will mean nothing if it's not applied to Diablo Canyon. That's a red flag. The California Coastal Commission, before the NRC ever is called upon to cast a vote on whether to extend the license or not, the California Coastal Commission must make a certification that the plant's relicensure would be consistent with the California Coastal Plan under the Federal Coastal Zone Management Act. When the Water Board was considering the once-through cooling issue last year, the Coastal Commission staff called Diablo Canyon the largest marine predator on the West Coast. That's a red flag. Probably more significant, though, and certainly closer in time, is the decision by the State Lands Commission that is pending in the next 2 years as to whether to extend leases for the intake and output facility.
If I can interrupt you, both San Onofre and Diablo Canyon were built before the Coastal Act.
Yes, sir.
In 1975.
Yes, they were, Senator. And before CEQA. In 1969. As a consequence, the State Lands Commission is now considering whether to require a full EIR for the extension of the intake and output leases at the plant. Those leases now expire in 2018 and 2019. If the Lands Commission were to extend the lease and enable a relicensing, it would increase the amount of nuclear waste generated by the facility by 82%. Now, if you assume that the Lands Commission might only extend the lease to the end of the current license, which I don't think is a realistic prospect, but if you made that assumption, it would increase the nuclear waste generated by the facility by 21%. Those are big numbers. And this is a decision going to be made by 3 constitutional officers in California, 2 of whom envision bright futures in statewide office, one of whom, my old boss, has a long history with the controversy surrounding this plant. In fact, one of the best film clips from that earlier era had a dark-haired Jerry Brown vowing to a cast of thousands of cheering people that he would do everything within his power to prevent the opening of the plant. That's a red flag. As a consequence, I think that it's important to assess how to mitigate adverse economic consequences in the county of San Luis Obispo if this plant happens to surprisingly close one night. Thank you very much.